One of the priorities of the Carney government in this fall session has been strengthening bail laws and tackling hate crimes. Now, those are slowly working their way through the legislative process, including at parliamentary committees. Now, the federal government is also dealing with the provincial use of the Notwithstanding clause. Some, including the federal government, have said that premiers are reaching for the constitutional tool just a little too often. That was part of my conversation with Canada's Attorney General and Justice Minister Sean Fraser. Hi, Minister. Thanks for being here and welcome back to Power Play.
A pleasure to be with you.
Now, I know your government is upset with some of the tactics that are being used right now in the Justice Committee by opposition parties to hold up some of the bills that you have coming through, specifically on combating hate, and the other one on reform to bail and sentencing. But I have to ask you, is this not a little rich of your party, considering how long your government has taken to get to this point?
Well, look, respectfully, Mike, we have come back in this fall setting with a torrent pace of advancing legislation in addition to the federal budget that's just gone forward. For my part alone, we've introduced 2 bills so far in this setting: the Combating Hate Act, which, as you pointed out, is being held up by the Conservatives at the Justice Committee, as well as the Bail and Sentencing Reform Act. We're not done yet. In this fall setting alone, we expect to have a 3rd bill to be tabled in Parliament that's going to be addressing gender-based violence, protection for kids, and a number of other measures. And there can be no reasonable accusation that the government is taking too long to take action. We are actively working to put these measures forward to improve public safety in this country, and we hope we can earn the cooperation of all parties in the House of Commons.
Well, I'm saying that because it was in 2019 that your government brought in what was known as the principle of restraint, where courts were instructed to release people accused of a crime as early as possible with the least restrictive conditions. And then in 2023, you also had tried to make an attempt at stricter bail laws. So this is really your 3rd attempt at this. So can you really fault the Conservatives or other opposition parties for trying to do their job in this committee by making sure that they're doing all their checks and balances? Isn't this what they're supposed to be doing?
Well, let's be clear. The tactics that are frustrating the process have nothing to do with the legislation that is actually supposed to be considered. What's enormously frustrating is when you look at the fact that the Combating Hate Act has arrived before the committee and the House of Commons has directed them to study this bill to advance it so we can actually implement it in laws. It's not met with serious questions about the contents of the bill. We are now seeing extraneous motions being put forward on issues where the government and I personally have actually broadcasted we're going to do the very thing that the committee is apparently asking the government to do, only to slow things down so they can look at other issues. Through the conversations that I've had with colleagues on the other side of the aisle, I know that there is support for these bills, and I know that there are divisions within the Conservative caucus. And if combating hate against religious communities, against racialized communities is a political controversy for the Conservatives, then they have bigger problems than the motion that they're putting forward at committee in order to frustrate the progress of this legislation.
I'll just come back to my other point, though. This is really the Liberal government's 3rd attempt at trying to amend some of these laws, specifically around bail reform and sentencing reform. I mean, so in a sense, can you really make the argument that others are trying to slow things down when your government has been slow enough in trying to actually get this law right?
Well, take a look at the difference in the measures that are included in the various bills that you're looking at. It's not as though that there was a decision taken years ago to take certain actions and they've been sitting dormantly. The bills that you're referring to tackled other, albeit related, measures. For my own part, having come into this position just before the summer, I spent the months following my appointment immediately talking to law enforcement who work within the system, to provincial governments who have responsibility for administering the system, and use the perspectives of those with responsibilities for the justice system to actually inform the bill that we put forward. We're now seeing that police associations, provincial governments are standing up and saying, we support this bill. We want all parties to cooperate to adopt it expeditiously. Whatever may have been debated years ago on related but separate items is not relevant to the conversation that we have a bill before the House of Commons now that should be studied, certainly, but advanced rapidly.
But with respect, isn't it relevant when you consider the fact that police chiefs in the past have been demanding these types of changes? And yes, they may applaud it now, but they were asking your government to do this the last time in 2023.
Well, I think we're dealing with separate issues here. Certainly, there are decisions that were taken in the past on the contents of particular bills that, in retrospect, could have been improved. We're doing that work now, taking in the perspectives of different actors within law enforcement and within the justice system to ensure that we get this right. But the problem that we're dealing with at the Justice Committee now has absolutely nothing to do with the content of the bills that are being put forward. It's the idea that the Conservatives are reaching for extraneous issues, trying to bring them before the committee in order to delay the consideration of these important bills, which seemingly they've been asking for a number of years. If they actually had serious questions about the bills themselves, if they wanted to call additional witnesses to better understand the contents of the proposed laws, that would be one thing and I could accept it. But when I see them bringing new motions on unrelated items for the purpose of slowing down the process of adopting reforms that law enforcement is asking for, the communities that are facing hate crimes are asking for, that is the source of the frustration, not the idea that they should take reasonable amounts of time to consider the contents of the bill itself.
I want to ask you about another very live debate around the provincial use of the Notwithstanding clause. While Premier Danielle Smith has used it twice in the last month, is it not her right to do so?
The Notwithstanding clause, it exists within the Constitution, and no one is disputing that. But I have some real concerns on the regularity with which we're seeing the Notwithstanding clause being used as a tool of first resort to deal with very complex and challenging social issues. You've got to understand that the Notwithstanding clause exists within a constitutional structure that already allows governments to adopt laws that impact the rights and freedoms that Canadians enjoy, so long as the laws that they adopt are reasonable limits that are demonstrably justified within a free and democratic society. Now, I don't know about you, but I think being reasonable in a free and democratic society is a pretty low floor that we should insist governments abide by in all instances. When you use a Notwithstanding clause, it's because you are indifferent as to whether the laws that you're adopting could actually be considered reasonable in a democratic society. My own view is that we should strive first to actually comply with the constitutional rights which Canadians are guaranteed under the Charter as we seek to address those complex legal issues, rather than using a sledgehammer when a scalpel may be more appropriate.
I'm asking you about this because I wonder whether or not there's a higher level of political consideration around opposing Alberta here and a couple of other provinces, but really when you compare it to Quebec, because it did take your Liberal government years to join in the challenge on Bill 21, known as the secularism law. So are you applying a different political lens because you have a lot more votes in Quebec than you do in Alberta?
No, and look, let me just clarify the record. I have a positive working relationship with my counterpart in Alberta, Minister Amory. I found him to be a terrific partner when it came to informing the work on the Bail and Sentencing Reform Act, and I think we need to look at the individual issues in isolation. Keep in mind, typically when you're dealing with these disputes as a matter of pieces of litigation, it's often the case that the federal government will allow the residents of a given province to take part in the litigation that may unfold at lower levels of court. Of course, now with the Bill 21 issue that you mentioned, that it's arrived before the Supreme Court of Canada, the federal government is certainly going to be making interventions. But what I find troubling today that 5 years ago perhaps was not quite as present in our everyday conversations is the regularity with which the Notwithstanding clause is being used to tackle a broad range of issues by different governments across the country. This is something that is not an issue as between federal and provincial governments. The use of the Notwithstanding clause is an issue that should be considered by both levels of government to be reserved for very rare sets of circumstances where the constitutional architecture is not equipped to be dealing with the kinds of challenges that governments seek to address. So it's really the more recent and frequent use of the Notwithstanding clause that shows that indifference towards the rights of Canadians as government seeks to adopt laws that gives me great cause for concern in more recent months.
So do you have an issue with the frequency as opposed to the basis upon which they use it? Because, again, I go back to the secularism law where the Liberal government and whoever was Justice Minister at the time, I believe it was Minister Lametti, basically sat on the sidelines as that was being used and as the Notwithstanding clause was being invoked before that bill even made it through, in a similar way to what Danielle Smith is doing now. I'm just trying to figure out how there's a difference in how your government has acted.
The frequency is one part of the challenge that I see, but I am yet to have observed an instance where the Notwithstanding clause has been invoked by any government since I've been elected a little more than 10 years ago, where I saw it as an appropriate use. For my part, again, having come into this particular position after an election where I'd remind you we have a new government with a new Prime Minister as well, I can only govern myself in accordance with the opportunities that come before me. We've made the decision to intervene before the Supreme Court of Canada when we're dealing with a law that was put forward by the province of Quebec. I'm willing to speak publicly when it comes to the invocation of some of those, that same provision rather, in a different context with other provincial governments. But the reality is this isn't about any challenge that I may have with one provincial government or another. I want to foster a positive working relationship with all of my counterparts, but this is about defending the Constitution. This is about standing up for the Charter of Rights and Freedoms and ensuring that we don't reach for the Notwithstanding clause, which does not suspend Canadians' rights, but instead allows a law to operate, notwithstanding that law may violate those rights which continue to exist. At the end of the day, we have to recognize that if we are not careful, our rights will be chipped away bit by bit until they are gone. I don't fear that our society will fall apart at the hands of some dictator on the other side of the world, but instead by some future government that is empowered by an erosion of our rights today. It's a responsibility that I have as Attorney General to defend the Constitution and the Charter, and I'm going to do that, discharge my responsibilities to the best of my ability.
Okay, Minister, we're all out of time. I appreciate you taking the time, though. Sean Fraser, the Minister of Justice and Attorney General of Canada, thanks so much for being here.
Thank you for the opportunity.